Yes.
It's a beautiful day in Northampton.
It always is.
It always is.
I hope you all had a wonderful, peaceful holiday weekend. Welcome back.
Take care.
All right, let's get started.
And Your Honor, just for the record, this is civil action number 1780CV00033, Patrick Buchanan et al. Versus the Town of Greenfield et al.
All right, a couple of administrative matters that we'll need to first address. The first regarding trial schedule. As I indicated last week, I was growing concerned as to counsel's estimate that this case would go to the jury on Friday, which is what we advise these good 8 jurors. We're still on witness number 1. And from my read of the case, there's plenty more to go. And I'm skeptical that you're going to meet that schedule. And hence, I'm concerned that we're going to lose jurors. Certainly in this civil case, we can go, we've got 8. So, we can go to 6. We could go, if there's an agreement, we can go below 6. If we don't, then I'll consider declaring a mistrial. On, I guess it was Wednesday or Thursday, I had a final pretrial conference for a 2 to 3 week long jury trial. Our first available date, which I gave to them, is May of 2023. So realistically, if there is a mistrial, you're looking at June of 2023, which has all sorts of horrible effects upon both sides. There's the ongoing incurrence of 12% interest to the extent that there are plaintiff's verdicts. Currently now it's somewhere around 86 or 84%, whatever it might be. And there's the pendency of this case for both parties, which I do not think would be a good thing. And so my message is to move it along, please. There is no reason why counsel was incorrect in its initial estimate as to the time frame of the case. I certainly felt that it looked appropriate based upon the papers. But we're still on Mr. Buchanan. As you know, we try cases on a half-day basis here in Northampton. That's just a reality, okay? I have asked the court officer to see if we could clear some time today and tomorrow with the jurors. I've got a packed schedule clear through Friday in afternoons with matters that unfortunately cannot be moved, criminal matters and the like. So understanding that, let me just ask, Officer DeRoche, did you have an opportunity to inquire of the jurors?
There's a couple of jurors that are making phone calls to see if they can clear their schedule.
Okay.
So that's still up in the air as we speak right
All right. What my thought is to go from 2 to 3:15. I'm just bumping all my other cases to 3:15. I've already taken some off the list, but I'm doing what I can. I could do that for today and tomorrow. I can't do it thereafter. Let me tell you also that the 27th, I have another matter in Springfield that is going forward, okay? And I won't be here in the morning. 28th and 29th, I have personal matters that take me out of state, and I can't reschedule them. So that if we keep going, then it will continue at some point in May, okay? Meaning May 2nd, I guess, if we still have jurors. Such is what you must understand of the realities of keeping a tight trial schedule, okay? Now, there was a very interesting question that Attorney Keston posed of Mr. Buchanan. I want to follow up on it, which was, what did you look at in advance of in between trial dates? And one of the answers was, I looked at my pension information, okay? When Attorney Ryan, you concluded your direct examination, you indicated that Mr. Buchanan was not going to be seeking any damages that related to lost retirement benefits. You were quite assured in that regard. That answer concerned me, and I am going to inquire whether or not on redirect you are going to try and get this another shot.
Yes, Your Honor.
Okay. Then it's fair game on cross-examination, okay?
Your Honor, I haven't touched
Or
it.
if I allow it at all, okay?
I haven't touched it on cross. They cannot go outside of my cross.
Well, that's an interesting, and I'm happy to hear from you in this regard. It actually was opened, not by a specific question that you asked, though. Your question was, have you done anything? And the answer was, yeah, I looked at my retirement information. I'm not convinced that reopens the issue on redirect to the extent that your question didn't call for that answer. So I'll hear from you in that regard.
Your Honor, being fearful of this, of not, doing more work on stuff that was never disclosed, etc. I have not gone into it. That question cannot possibly open it. If I started cross-examining him on this, or asking him questions
Right.
about his retirement, why didn't I didn't. I simply asked him. It's a standard question. What'd you do? Just because he put that out there does not open the issue that they can now have him do more calculations.
I don't entirely disagree with you.
To which, Your Honor, we can't respond.
I don't entirely disagree with you, but I do need to take a look at it. What do you have to say about that, Attorney Ryan?
Your Honor, I pulled something.
And this puts aside your client even being able to lay a foundation as to his competency to testify as to a matter which he effectively conceded earlier. But having said that, what do you have to say about, at least on the scope issue?
Your Honor, I pulled Schwartz, the third edition trial handbook for Massachusetts lawyers. Section 14.13 says the judge may, in his or her discretion, allow the introduction of new evidence during redirect. And it cites Com v. Padalano, 254 Mass.
Okay, why don't you provide a copy of that to counsel myself? I'm going to have to look at this during our mid-morning break. I'll just be blunt. I'm not inclined to allow it in, especially after counsel on the record said you weren't going there. But I'm addressing this now because the delays in this trial have been, in certain regard, unnecessary. But I will take a look at that case, and I'll hear from counsel further after our mid-morning. Well, depends how much more you have, I guess. We'll take a break, then I'll look at it, and then we'll see what happens on redirect. I also spent time this morning going back through my notes, and I'm not going to permit on cross-examination going back to issues that have already been addressed. I'm sure you respect that. That all goes to moving this case along. We have plenty of other evidence to go. All right, I did receive the motion for mistrial. I received your opposition. I appreciate it. I have not looked at them yet. I will take them under advisement, okay? If I believe that further oral argument is necessary to the extent that I read something that is new with that I believe would benefit from oral argument, I'm happy to hear from you, okay? Otherwise, I'll rule on the papers. And I have plaintiffs' proposed jury instructions, which I appreciate. I don't have defendants. I've impressed you on it because I respect that these are a work in progress. But if Friday's our date to go to the jury, that's coming right up. So, what are your thoughts?
Oh, we should be able to get you something.
Tomorrow?
Hopefully by tomorrow. Yeah.
That's fine. Tomorrow by, let's say, you can get to me at 2. Because I actually work on these things, so I don't mean to be glib about that, but that'll give me time to do it because Thursday will be plenty busy.
We'll do that. Yes, and in terms of the afternoons, I'm just trying to think. I'm trying to look at my schedule. I know I've got a 3:00.
I respect all that.
And I'm just thinking out loud.
I'm only looking for today and tomorrow up till 3:15, and I fully understand that counsel are busy. I haven't forgotten what it's like to be a lawyer and have a judge tell you all of a sudden you need to be here. But in this case, you do need to be here, okay? Let me just say this. The taking of evidence in a trial that oftentimes brings parties and counsel to an understanding of the likelihood of success on either side, okay? And let's move this case forward, okay? No one's going to fault anyone if this case resolves short of a verdict, okay? And given the stakes in this case, and let's, once again, 12% interest is the best investment in town. Let's not forget what the ongoing occurrence of interest does. Let's not forget what the specter of appeal does. Let's not forget what the further incurrence of attorney's fees and costs does. And I'm going to leave it at that. I do have a motion to compel a trial settlement that I need to address. Have you conferred with Attorney Keston relative to this motion?
Yes, Your Honor. And what we're looking for, and I think we're in agreement, is everything's been produced except for the records with respect to the 2014 civil service promotional exam.
Okay. And is there an agreement to produce that, Attorney Keston?
First, I just want to be clear on this. This is something Is there going to produce it? If we can find it, we're looking for it right now. So, Your Honor.
Yeah, and that goes without saying. I mean, if counsel represents there's been a diligent search and you can't find it, then
Just so
it is what it is.
They're doing discovery outside the deadline.
Pardon me?
You cannot use trial, as I understand it, you cannot use trial subpoenas to avoid the discovery deadline. This is something that should have been discovered 5 years ago.
Well, I mean, I get what you're saying. At the same time, no one, there may be legitimate reasons to oppose a trial subpoena, okay, that may hark back to some sort of objection that you may have made to discovery. I respect that. But otherwise, if there is a trial subpoena and if there's no objection, then it needs to be respected. Yeah, I'm listening.
Your Honor, we discovered the same thing on Saturday, I think. When we're looking at it, we've never seen this, so we are inquiring. So it's yes, we are using our best efforts to get it.
Right, well, we'll do this because this gets to trial scheduling, okay? So I can't give them a week to produce these documents. And the subpoena was issued some time ago, not too long ago, but some time ago.
In March.
All right, very well. I'd like to report back on this. I take it they're working on this morning?
As we speak.
Okay. I'll hold off on this for right now. I think that's all I have other than word back from the jurors, and I certainly respect that counsel may need a moment to see what they could do about rearranging their afternoon schedule. So, Officer DeRoche, do we have a response yet from them?
Not yet. One of the jurors, Your Honor, is still inquiring. I guess they're still making phone calls to see if they can
Okay.
today and tomorrow.
Okay. Right. So they're not ready to come back in.
Not yet, Your Honor.
Okay. All right. Does counsel want a moment to see what you could do to rearrange your respective schedules? And I'll step off. I do want to get us started as soon as they come in. And I wish I could give us more than an hour and a quarter, but I've got about 3 hours of other work to do on top of that, in court work that is.
And Your Honor, could you just tell us again, is it the days next week that you're busy?
The 27th. Effectively, I'm not going to be here on the 27th. I could be here. If the jury's deliberating on the 27th, that's okay. Okay? I'm not here on the 28th and 29th, okay? And I'll be blunt with you. I'm dealing with an ailing 93-year-old mother in Florida, okay? And I'm not canceling that. And I'm sure none of you would want me to. And that was something that was scheduled a long time ago, okay? But I'm happy to come back that Monday and continue the trial that I have scheduled to start on that Monday down in Springfield for that purpose. But that Thursday and Friday, I'm sure you could respect, I cannot be here.
What about Wednesday?
That's the 27th.
Yeah.
I've got something in the morning. Pardon me?
That solves my problem, because I have this MCLE with Judge Chernoff on the 27th, that I can, if I have the morning.
Actually, I was going to be attending as a spectator.
Well, you're watching some of it.
I will leave it at that. No.
But anyway, thank you.
I have a sentencing that morning on
So
on the
I can
case.
I can tell MCLE that I can do it in the morning.
Oh, absolutely. Yeah. What time is it?
It's supposed to be 9. It starts at 9. I mean, it's an hour.
That's fine.
I can limit my participation.
That's fine. I'll be back here probably by about 11. But I also, and I think it's by Zoom.
Obviously.
Right. If the jury's out on that day, that's fine with me. I do have a committee that I chair at 3:30, and I've got a meeting on that day. And that's a continued hearing, meeting. So I'd like to do that, but if I need to reschedule that, I will do that. So that's what we have. So I'm just putting it all out there so you understand what I deal with, because it's it belongs to all of you. Okay, all right. Very well then. Does counsel need any more time? Otherwise, I'm going to check up on our jurors to see if they're ready to come in. Attorney Keston, do you need to step off to clear your schedule for this afternoon and tomorrow afternoon?
5 minutes would be great.
That's fine. All right. Okay, we'll give you 5, and then I'll see you.
Don't give us enough time to leap up.
All right, we're back on the record. I understand that we don't have all jurors available this afternoon, but they're all available tomorrow afternoon. I'll tell you, maybe we'll go from 2 to 3:30. It might be a little shorter, but we'll do that. So it's something. I think we're ready to bring them in. Let's get started, okay? Mr. Buchanan, good morning, sir. If you'd be so kind as to retake the stand, and you can point the microphone directly toward you. Let's bring in the jury.
Sure. 2 minutes and I'll be right
Oh, no,
back. I just wanna see if
Save yourself.
No, I'll be right back. I just want to see if I can make people's lives a little easier.
Remember, if you look angry, people think you're busy. It's true. That's why Phil Davis, the original
Jury entry. Hampshire County Superior Court is now in session. Please be seated.
Well, good morning, ladies and gentlemen, and many thanks for your patience. First, I'll inquire, has anything come to your attention over the long holiday weekend which has affected your abilities to remain fair, to remain impartial? No affirmative responses. Now, I do greatly appreciate your having considered adding some additional afternoon time to our trial. I don't ask you to do that lightly at all. I fully respect that we give you an approximation of a schedule, and we tell you when our court day is, and we try to stick to that so that everyone has some ability to plan ahead. We're running a little bit behind here, and I am concerned about continuing to meet our estimated date of this Friday for the case to go to you for your deliberations. And that's why I requested, as I did, that we add some time in the afternoons. And as I understand, you're all available as our counsel and the parties for tomorrow, Wednesday afternoon. Just so you know, we take the lunch break. The entire complex closes down between 1 and 2. We'll come back at 2. I think we'll probably go to 3:15 or so. I actually do have many other matters in the afternoon I still need to handle. I just push them all off. So I do appreciate your having taken that opportunity. All right, we're going to resume the cross-examination of Mr. Buchanan, who remains under oath. Good morning, sir.
And Justin, would you put the tab 47, 48 in exhibit 4?
Thank you, sir.
You're on the screen. Yeah. Good morning, Mr. Buchanan.
Good morning, Attorney Keston.
You have before you Chief Donovan's report.
Yes, sir.
Have you seen it? Have you read it before?
Yes, sir.
You're aware, Chief Haig promoted you to provisional sergeant in October of 2017, right?
Yes, sir.
And you're a provisional sergeant. working what shift?
I worked both 3 to 11s and 11 p.m. to 7 a.m.
When did you first hear that officers that you supervised were complaining about you?
It was in the fall, heading toward, I think, fall of 2017.
At that
I'm
point-
sorry. Yeah. Fall of 2018. I'm sorry.
18.
Yes, sir.
And if you look, and I have a page, it's number 2 in the lower right. I have it up on the screen. If you look, it's about the 5th actual page, but on the lower right-hand corner it says 2. You see that background information?
Yes, sir.
And at that point, Officer Green was the president of the Patrolmen's Union, right?
I believe that to be true, sir. Yes.
And you see that in the Donovan report, it was Officer Green that brought concerns about your ability, your style of supervision to Chief Haig in October of 17, right? I'm sorry, not in September of 18.
Yes, sir.
And then Chief Haig spoke to 12 staff members about problems.
Yes, sir.
And that the Chief Haig heard about problems with Sergeant Westerling and yourself, right?
Yes, sir.
You were a provisional sergeant, right?
Yes, sir.
And Westerling was a full-blown civil service sergeant, right?
Yes, sir.
So the only way, well, okay. And at this time, you had a lawsuit pending against the chief, against the town of Greenfield based on the actions of the police chief, right?
Yes, sir.
We go to the next page, please. See that Chief Haig, on October 15th, was handed a written statement from the union president. Written statements from 4 Greenfield police officers, right?
Yes, sir.
And they were Jeffrey Soto, Jordan Zukowski, Michael McDowell, and Sergeant Jason Haskins, right?
Yes, sir.
And those complaints are what triggered the investigation. Right?
That's my understanding, sir. Yes.
And then Mr. Chief Donovan spoke to 10 people, 10 police department members about your treatment of subordinates.
Yes, sir.
And we go to page 8. You see that as to the taping of the locker,
Yes, sir.
Chief Donovan finds that you were resorting to negative reinforcement and bullying tactics to teach these subordinates a lesson, right?
That's what he wrote. Yes, sir.
We go to page 10, please. Chief Donovan expresses his finding that you did not do any verbal written documentation, but you chose to teach Soto a life lesson using unapproved and unacceptable methods, right?
Yes, sir. That's what he wrote.
on page 13, please. Chief Donlan said that he did not insufficient evidence to sustain 3 of the incidents, right?
That's correct.
Complained about.
That's correct.
Page 14, please. In the last paragraph, many of the officers interviewed by this investigator who had first-hand knowledge of the alleged micromanaging and demeaning tone used on them by Provisional Sergeant Buchanan complained of Buchanan over-supervising them and not letting them do their jobs. I read that right?
Yes, sir.
So on page 17, please, Chief Donovan, of the 6 complaints about you, sustained 3, and did not sustain 3 others, right?
That's correct, sir.
And the only, as a result of this, Chief Haig issued you a letter of reprimand, right?
That's correct.
And a letter of reprimand is something that you can appeal through the union, right? You can read it.
That's correct.
So if you think that the letter of reprimand was inappropriate, you could have filed a grievance.
Could have, yes, sir.
But you didn't.
I chose not to.
You accepted it.
I just chose not to fight anymore.
Okay. And you remained a provisional sergeant. You were not demoted at the time you got the letter of reprimand, isn't that true?
That's not true.
You claiming you were demoted in relation to this investigation?
I was demoted first and then got the letter afterward.
Your demotion had nothing to do with this investigation, did it?
I don't. I want to be careful to. Can you repeat the question again, sir?
Your demotion had nothing to do with Chief Donovan's findings in this investigation, did it?
I don't know.
Well, Chief Haig told you, verbally and in writing, why he was removing you as a provisional sergeant, did he?
That's correct.
And Chief Haig told you that they needed more patrolmen on the street and they were going to go down 1 sergeant.
That's correct.
And you were the least senior sergeant.
That's correct.
Now and this happened when were you removed as sergeant?
The middle of January, I believe.
Of 2018?
2019.
19. And by then, you had told your doctor and Mr. McLean that you were, Dan McLean, that you were retiring on September 27th, 2021, hadn't you?
I don't recall that, no.
Have you looked at the notes to see how many times you told them that?
I looked at the notes. I discuss stuff with my therapist. And anyone who's retiring at some point in their lives starts putting dates out there, starts thinking about those things. And in therapy, that was one of the things that we discussed. So yes, I discussed dates in the future for retirement. However, if things were all okay, there'd be reason for me to stay.
You told your doctor, the PCP, on more than one occasion that you were retiring on September 27th, 2021, years before, didn't you?
That's what he may have put in his notes, but that was not the totality of the conversation.
But that's what it says in the notes, right?
That's correct.
And with McLean, you had told him 10 years before that you're going to retire in 10 years, right?
And that, again, might have been a discussion back and forth with my therapist.
You see what he wrote?
I saw what he wrote, yes, sir.
That you told him, I'm retiring in 10 years, I'm going to try to stay out of the way and do as little as possible so I can get my pension in 10 years. Right?
That's what he wrote.
And that was long before any of the things that you allege were done wrong to you happened.
With respect to the narrow view of this case, yes.
The narrow view of the case that you brought.
Right.
We're trying the case that you brought, right?
Yes, sir.
And years before this case. Okay. So there was another promotional process in 2020, right?
Yes, sir.
That involved an assessment center? Or was that out of civil? That was out of civil service, right?
I don't believe that process involved this. To answer your question, no, sir.
Is it true that by then Greenfield had gone out of civil service?
That's my understanding, sir, yes.
And the union supported that, didn't they?
That's my understanding, yes, sir.
And Todd Dodge supported getting out of civil service, right?
I'm not privileged to know what Todd Dodge's position on that was.
So the process in 2020 involved an exam, right?
The 2020 process?
Yeah.
I don't recall an exam.
What do you remember the process being, Mr. Buchanan?
I remember it being an interview, a chief's assessment, and a grade for your education and experience.
So the interview was with who?
The police commissioners,
Public safety?
public safety, and yeah,
And the chief's assessment, right?
correct,
And the chief graded you low.
correct.
And he told you why, didn't he?
Not to my recollection, no, sir.
Sir, by 2020, you had been sitting at the tire warehouse and avoiding doing any work for about 5 years?
That's incorrect. There's nothing that I have been told or issued, no complaints about the volume of work that I was doing, and certainly no complaints about me setting up on the busiest street in Greenfield so that there was a police presence there that I was doing anything wrong.
Sidebar, please.
I've heard very, very little in the way of objections in general from plaintiff's counsel. In an effort to move this forward, I'm going to entertain objections based upon asked and answered. This certainly is material we've gone over many times, as was material relating to conversations with the therapist in retirement. Okay, so we've got to move this forward. Thank you.
Chief told you in 2020 why he was giving you a low grade, didn't he?
I don't recall that at all, sir.
Do you remember sitting down with the chief who explained to you that, one, your level of activity was virtually done?
I don't recall that conversation, sir.
Do you recall him telling you that you had you were using way too much sick time compared to everybody else?
Yes, because I remember I remember that conversation.
You remember a conversation with the chief about why he graded you down? No.
I remember him having a conversation with him about sick time and explaining that the reason why I used sick time was that I was sick.
Okay. And did you tell the chief that if they made you a sergeant that maybe you'd work more?
I don't think that I phrased it that way. I believe what I said to him was that when I was in a supervisory position, I was certainly more inclined to come into work because I knew that other people were relying upon me as a supervisor. So if I wasn't feeling 100%, I'd still grind it out and come into work. But in or about 2017, 2018, with my type 2 diabetes diagnosis, I started experiencing some health issues that being that first line upfront officer requires a little bit more involvement with what's going on out there. So, yeah, I took the available sick time that I had to address my illness, and the fact that the chief used the fact that I was sick as a reason to not promote me is.
I didn't ask him anyways.
Please ask another question.
You have for years been using up all your sick time every year, haven't you? Long before this diagnosis.
If that had been the case, I wouldn't have had any sick time left. If I used up all my sick time, as you just said.
You get how much sick time do you get every year?
I think it's 12 days.
12 days. You've been using up those 12 days for years, each year, hadn't you?
No.
And you told the okay. So you now remember a conversation with the chief only about sick time?
That's the best of my recollection as we sit here now. Yes, sir.
Since you brought up this lawsuit, as far as the one that you filed, the one we're trying, begins in 2014 when you took a civil service test in October, right?
That's correct.
And then nothing before.
I'm sorry?
Nothing before.
I don't understand the question.
Nothing in this lawsuit that involves any other decisions made before the fall of 2014 is there.
Respectfully, attorney, you have brought in a lot of things that happened before, so with respect to this whole case, we are talking about things that happened before, so you're talking about my meetings with my therapist. Those happened before. If in 2014 I didn't have any desire to be promoted, I would not have taken the test. And I tested previous to that. I've been testing, pretty much all my career. And if I had conversations that said, "Hey, these are the parameters that we need to use to judge you as being promotable," but in 2014, there's one set of rules, civil service. The following year, there's an assessment center, a different set of parameters that we're using to address promotionability. To 2020, yet another set of rules. And the fact that I can't remember the timing of the conversation with the chief, to be truthful with y'all. So when the chief had made those declarations about my sick time use.
All right, fine. Thank you very much. Please pose a question.
Thank you. You put in your papers on September, I took your deposition, your third deposition on September 27th, 2008, that flies, 19, right? I'm sorry, 2021. 2021, I took your second deposition on September 27th, right?
I'm sorry, can you repeat?
On 2000, and I took your
Objection,
third
Your Honor.
deposition.
Wait till there's a question, please, so I can rule on it. And I'm happy to hear from you once the question's been formulated.
September 27th, 2021.
Objection, Your Honor.
I still don't have a question yet, so please wait till there's a question, then I'll entertain your objection.
No, okay. Isn't it true I took your third deposition on September 27th, 2021?
Objection, Your Honor.
Sidebar? Was the objection, was it now the third deposition?
Your Honor, this has been asked and answered, I believe.
There's no question yet. This is a waste of time. Please wait till there's a question. All I have is, I took your third deposition in 2021. Was there a third deposition on September 27, 2021?
Yes.
What is the question going to be?
And at that deposition, I asked you if you're going to retire. You said you hadn't decided yet.
Okay, and that's been asked and answered, so I'll rule that in advance. But in
Your
the
Honor.
future, yes.
He was allowed to go on for 2 days. I am finishing up.
That
In the next
question,
5 minutes.
that question has been asked and answered, though. Okay, but in the future, please wait till the question has been formulated.
Okay, so I'm not allowed to ask it.
What? That question you can ask and you'll allow for objection. I'll sustain it. It's been asked and answered, actually more than once. Let's move on.
When did you put in your retirement papers?
I believe it was the 28th of September, 2021.
After the deposition.
Yes, sir.
Nothing else.
Very good. Redirect. Let me see counsel at sidebar. Okay. I have been doing some research while we've been moving forward on the scope of redirect, which is clearly within my discretion. There's one case that I need to look at, and I haven't had a chance to read it. So I'm going to ask you to move on with other topics, and then we'll take a very brief break. I'll take a quick look at that case and hear from counsel as to the issue of retirement. I'll tell you right now, I'm disinclined to allow it, okay? Especially on the record, counsel represented that you aren't going to go forward with it. But I'll address that after I take a look at the case.
Just on that point, Your Honor, at the time when we were here the other day, he was unable to do the equation. And that's, I believe, what we represent to the court, that he couldn't do the
This
equation.
only goes to the scope.
Yeah.
Okay, I'm not convinced when counsel asks an open-ended question of what did you do to prepare, I look at my retirement, that actually opens the door, okay? But once again, you're getting ahead of yourself. There's a case I want to look at, okay? I haven't had a chance to look at it because I'm sitting in here at trial with you all, okay? So let's proceed. We'll take a brief break, then I'll hear from you. If it has to do with that issue, I'll hear with you. As I just said, I'll hear argument a little bit later. Let's move forward on other issues.
Mr. Buchanan, there was discussion the other day about internal affairs complaints brought against you, correct?
That's correct.
And over the weekend, did you review the file?
I did.
Okay. And were there complaints brought against you by Sergeant McCarthy.
Your Honor, I guess a brief sidebar.
Sure.
There's something I printed out on the printer. If you could bring that in my lobby. Sure. Yes.
We have an offer. We want to put into evidence all those IAs. They're objecting. I was asking questions about them. So they're going to go in.
Yeah, I don't have any objection.
You did object. He objected.
We withdraw that objection, I'm sorry.
Thank you. So we're all done.
All right. Have they already been entered into evidence as one of the existing exhibits? I take it they're not.
No, they weren't agreed to.
Okay, so then on recross, then they can seek to introduce them, or you can introduce them, but we'll figure it out, okay? All right, thank you.
They're on the contested folder.
Right. Let's continue.
With respect to the IAs, how many were brought by Sergeant McCarthy?
I'm not sure of the exact number, sir, but a majority of them were.
Who is Brickett Alice?
Brickett Alice is a former town councilor, resident of Greenfield.
Did you ever arrest Mr. Alice?
No.
Did you ever cite Mr. Alice?
I don't recall, but I don't believe so.
And were there IAs brought against you with respect to Mr. Alice?
There were.
Kelson Ting is a former police officer?
That's correct.
Did you review IAs having to do with Officer Ting?
I did.
Okay. And from the IAs, did you come to an understanding as to when and how Officer Ting left the department?
I object.
Sidebar?
You know, I would encourage you all. I recently had an opportunity to use these whisper mics, and we had a lot of lawyers that worked very well. I got to tell you, wherever you go, ask for them because they save a lot of time. Because all the sidebars we've done at counsel's table, they work very, very effective. Just a practice note. There's nothing to do with this trial. No. I mean,
Whisper.
I have them cup their hands over the mic, and we test drove it. It may not work in a small courtroom, but you have to make sure that the white noise machine is loud enough. All right, what is the objection?
Come to an understanding. He can. How can I ask him? Could you come to an understanding?
Okay, you wish to reply.
Your Honor, it's in the Ting IA where he resigned.
Why don't you lay a foundation and then we'll proceed, okay?
Please lay a foundation.
Thank you, Your Honor. What's your understanding, Officer Buchanan, as to the town's residency requirements?
At what point, sir?
In the 13s and 12s.
It was my understanding that you needed to live within 10 miles of the border of Greenfield.
May I approach, Your Honor?
You may, counsel, do not request leave of court to approach any witness. Thank you.
Could I see what you're showing?
Oh, I'm sorry. Can you identify that document, sir?
This is a request that
Well, who's the document from?
the document is from Brody, Hardoon, Perkins, and Keston.
Okay. So Attorney Keston's office,
That's correct.
and it's dated when?
September 28th, 2017.
And who's it addressed to?
It's addressed to Dan McLean.
Okay. And could you read aloud the first two sentences?
Enclosed, please find an authorization executed by Patrick Buchanan for the release of his medical records and bills. I kindly ask that you provide this office with copies of Mr. Buchanan's medical records and bills from January 1, 2007 to present.
Note 2615. Yep.
So you're showing him those notes.
Yep. This is a note from Dan McLean, correct?
That's correct.
Okay. And could you read the under follow-up under February 6, 2015?
Pat was distraught over recent actions by his supervisor that resulted in a revocation of his departmental status and a 3-day suspension that stemmed from his conduct while policing. He reported his depression has been more pronounced and his anxiety and stress levels have been very high.
Okay. And there's a note, February 16, 2015?
That's correct.
Okay. Can you read that?
Pat's depression has worsened, and he has been experiencing high anxiety and poor sleep. He has met with the mayor of Greenfield to discuss his concerns regarding his conduct and consequent actions that have resulted in high stress and feelings of mistrust at work.
This is 10/26/17. Give me your note dated 10/26/17. Again, this is from whom?
This is from Dan McLean,
Okay.
my therapist.
Read the follow-up.
Patrick has obtained a provisional promotion to sergeant in the department. He denied feeling any additional stress associated with dispatch and reported his stress levels have been mostly manageable. He noted his motivation to exercise has been higher than any time in the past few years. And
If I can. There's 2. 829 at the bottom. 1647. No problem. I'm directing your attention to the note at 8/29/2018.
yes, sir.
Could you read it down to where it says frustrated subordinates?
You want me to start at the beginning and read it too? Okay. Examine the inner conflict between the Good Samaritan and the straight and narrow mechanics of law enforcement. Patrick admitted to role conflict and heightened anxiety when he compromises, is not being who I am. He identified with an old school approach that is pro-social and community-based. Pat's stress extends to the supervisory role as well as concerns about politicized policing. We discussed concerns about the negative impact of indirect complaints from frustrated subordinates.
Would this be more or less contemporaneous with the time you learned that your subordinates were complaining about you?
That's correct, yes.
Could you read the note at 11/6/18?
Pat reported feeling less anxious this week, but he continues to experience bouts of high anxiety that are transient and related to tensions that arise in his supervisory role, which put him, quote unquote, on edge, and the ongoing stress of, quote, not knowing, end quote, the nature of the allegations lodged by his supervisor. We reviewed container skill, which was not effective due to difficulty with imaging.
Okay, thank you. One last. 1:15:19. Showing you a note, could you take that, sir?
The top note is 131:19.
Okay. And could you read aloud what's in that note?
Discuss Pat's ongoing anxiety and stress over his demotion that starts next week. His sleep has been irregular, waking in the middle of the night, and ruminating over his actions at work. We discussed the idea of writing about his worries when he awakens instead of using the TV for distraction. Pat has been using controlled breathing, 6 in, hold for 6, breathe out for 6, which has been helpful. He spoke about low morale in the department and mentioned feeling some support from a select few officers who understand his predicament.
In the last line?
Pat mentioned Celexa has continued to be helpful, making the lows less frequent and intense, and noticing that he feels less depressed overall.
With respect to any of the IAs that preceded the January 2015 IA, the internal investigation conducted by the department, at any time were you required to give a recorded statement?
No.
At any time do you recall any discipline imposed against you?
I believe once I was removed from my role as a field training officer, but that was for a short period of time.
And that was by whom?
I don't remember.
Attorney Keston asked you about people who you may have identified as racist.
Yes.
Do you recall him asking you about Chief Gilbo?
Gilbo, yes.
Okay. And your answer in response to Chief Gilbo was what?
Yes.
Okay. And the basis for your opinion or your response that you felt Chief Gilbo was a racist was what?
A fellow officer had explained to me an incident that took place with Chief Gilbo, where he was giving Chief Gilbo a ride home after being out drinking, and while driving through Montague, Chief Gilbo had observed a group of young black men and had yelled the N-word at them as they were driving by.
And Chief Gilbo left the department approximately when, sir?
2012-ish, I think.
There was discussion about Lieutenant Magnan, correct?
That's correct.
Okay. Did you identify Lieutenant Magnan as somebody who you identified as racist?
Yes.
Okay. And why did you respond that you identified him as someone who was racist?
Fellow officers overheard Lieutenant Magnan at that point referring to me as a lazy N-word.
And when did Lieutenant Magnan leave the department?
In or about 2012.
And these individuals would have been on the department from the time you started up until the time they left?
That's correct.
No further questions. Okay, Your Honor, may I be heard at sidebar?
Certainly. All right with you.
Yes, Your Honor. So I'm asking to reopen, to put in the 3-year differential on the pension, lost pension.
Is there an objection?
Yes, sir.
The objection, please.
Number one is that this is redirect. I never touched it on cross. Number two is you can't do this. He's already said no. We're in the middle of a trial, and he's trying to elicit testimony with no notice. None.
Okay. The objection is sustained. On April 14th at approximately 9:07 a.m., as Attorney Keston resumed his cross-examination, he asked Mr. Buchanan what he had done in the overnight hour to prepare for his ongoing testimony. In response, Mr. Buchanan testified that since April 13th, he had slept, he prepared a calculation of retirement, he spoke with his lawyers 3 to 5 times, and reviewed paperwork. He reviewed documents that represented the retirement board forms. On April 13th at 12:23, after significant sidebar communications relative to Mr. Buchanan's competency to testify as to retirement, Mr. Buchanan, through his counsel, effectively conceded that he was not competent to testify as to his retirement calculations. Under Mass Fact Evidence 611E, the scope of subsequent examination, including redirect, is within the discretion of the trial judge. In this particular instance, I do not find that Attorney Keston opened the door relative to the issue of Mr. Buchanan's alleged loss of retirement. His question, which was an open-ended question, resulted in an answer which it did indeed state that he had prepared calculations of retirement. But when viewed in the context of counsel's effective representation to the court, that this particular witness was not competent to testify, and viewed in light of the question which was posed and an errant answer that brushed upon the issue of retirement. I'm exercising my discretion, and I'm going to exclude that testimony.
Your Honor, can I just be heard for a minute?
Sure.
Thank you. Your Honor, he has
I'll
done...
note you were heard, but I'll give you an opportunity to give it another whirl.
He's done the calculation, Your Honor. It would take 3 to 5 minutes, maybe 10 minutes, but he's done the calculation. He has the capacity to testify, and it would be in line with the proof of damages through both the Boothby versus Texon as well as the Haddad versus Walmart.
Okay. That's your offer of proof. The objection is sustained.
I believe that there was a follow-up. There was a follow-up from Attorney Buchanan.
I mean, you're not Attorney Buchanan's lawyer.
Mr. Buchanan.
Pardon me, Mr. Buchanan's lawyer. So the objection is sustained.
No further questions, Your Honor.
Recross, strictly limited to redirect.
So, Mr. Buchanan, you've now reviewed all the other IAs,
Yes, sir.
so you agree that when you told the jury that you only had 2 in your career, you were grossly mistaken
I was mistaken.
by a factor of 20 to 2, right?
Yes.
And I note that you, on redirect for the first time, talked about, strike that. Your lawyer and you went over your therapist records since the beginning in 2015, right? Just now.
I'm sorry, can you repeat the question again?
Sure. The first record he showed you now on redirect was in 2015 record, right?
Yes, that's correct.
But you've been seeing Dan McLean for 10 years before that.
That's correct.
You've been reporting to Dan McLean insomnia, poor focus, nightmares, depression, difficulty following through with duties at work for years, right?
That's correct.
You had those conditions when you first saw McLean, and the jury's going to get to see it. And you had those conditions throughout up until 2015, didn't you?
That's correct.
And you told Dan McLean that you had trouble sleeping. Nothing else.
Sorry, was there an answer to that last question?
It was a truncated non-question.
Then it is struck from the record. Okay. All right. Very well. Any redirect limited to recross?
No, Your Honor.
You may step down. Thank you, sir. Okay. And Ryan, you may call your next witness.
Chief Hague, Your Honor.
Okay. Very well, Chief Hague. Good morning, sir. Please step up. We'll swear you in.
Do you solemnly swear the evidence which you shall give to the court and jury in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God, or do so? Thank you, sir. Watch your step.
Right, sir, please make yourself comfortable speaking directly into the microphone in a loud voice. And Officer DeRoche, if you could maybe clear the, Officer Busey, clear the witness stand of whatever is on there. So, thank you. Great, thank you very much. You can just put that on the exhibit table. Thank you. Okay. Whenever you're ready, counsel.
Good morning, sir.
Morning.
Could you state your full name?
Robert Hamilton Hague, Jr.
Okay. And your position with the Greenfield Police Department?
I am the chief of police.
And you have been the chief since when?
I believe November 2013.
Okay. And just briefly, if you could tell the jury your career, where you've been in terms of your career as a police officer, sir.
Certainly. I started with the Orange Police Department in April of 1998. I put myself through the police academy and graduated in 1999 with Orange as a sponsor, but I was a self-sponsor. I paid for myself. I was shortly out of the academy and I transferred to Greenfield, I believe at the end of 1999, October-ish. I was with the Greenfield Police Department until, I believe, February of 2002, when I transferred back to the Orange Police Department. I was in the Orange Police Department up until I became the police chief in 2013 with Greenfield again as a transfer once again.
Now, attorney, you were here for the openings, correct? For the opening statement?
Oh, sorry, you said attorney, so.
No, I apologize. You were here for the opening statement, sir?
I was.
Okay. And you heard Attorney Keston state in his opening that you had been a defendant for 7 years, correct?
Yes, I believe so.
Okay. That's incorrect, isn't it?
I know this has been going on for 7 years.
But you, the town, has been a defendant for 7 years, correct?
Yes.
Okay. You haven't been a defendant for 7 years.
I believe I was named recently.
Okay. And after the 2021 promotions took effect, correct, sir?
That would be correct.
So you have only been a party to the litigation for a little over a year.
I've been involved since the beginning, so I would assume I've been a party to this the entire time.
You are a party now. You are a named party, correct?
I am now.
Okay. But you were not a named party until approximately a year ago.
I object.
Asked and answered, sustained.
You transferred back to Greenfield in 2013, correct?
That's correct.
Okay. And you came in as a chief.
That's correct.
And it was a civil service chief?
Yes, sir.
Okay. So you're protected by civil service?
I am.
Okay. And at the time you came in, there was no ongoing competition, correct?
I don't understand your question, sir.
At the time you came into Greenfield, you were not one of several candidates for the chief position.
That's correct.
And Robert Hawkins is the father of your ex-wife?
That's correct.
Okay. And he goes by Butch Hawkins?
Also correct.
Okay. And Butch Hawkins has been the chair of the Public Safety Committee since you came back?
Public Safety Commission? Yes, the chair.
And Mayor Martin would have appointed Butch Hawkins to the Public Safety Commission?
Yes. I shouldn't say that. The mayor, I don't know which mayor appointed him, actually.
But he stayed on?
After I was there?
Well, he's been there from at least 2013 to date.
Correct.
And rather than in a competition with several other officers, Mr. Hawkins told you there was an opening?
Not exactly.
Okay. Well, he told you that they were looking for a chief, correct?
That is correct.
Okay. And he arranged for you to have a meeting with Mayor Martin?
That is my understanding.
Okay. And based upon your meeting with Mayor Martin, you were then hired on a lateral transfer as chief, correct?
More or less, yes.
You agree that the town or the police department does not have productivity targets, correct?
Correct.
Okay. Arrest and ticket quotas would be illegal, correct?
That is correct.
And the town or the police department does not conduct annual evaluations of its staff, correct?
Not since my arrival.
Okay. Were they doing it before you arrived, sir?
I do know that there was some form of it because some people have them in their personnel records.
Some people have what in their personnel records?
There's performance reviews sporadically.
In the past?
In the past.
Okay. We could pull tab 33 from book 1. Oh. There were two separate documents in this exhibit, correct, Chief?
There's several pages in this.
We're just waiting for it to load. So the first two pages are of the officers who were candidates for promotion in 2020.
It appears so, yes.
And the next set of pages, Chief, is a listing of all the officers who have served, or all of the personnel who served in the department from 1/1/99 to 4/22/21, correct?
I can't be 100% positive.
Okay. Would you accept my representation, Chief, that on page 1 of this longer sheet, there's 33 names?
The tab number again, please.
Your Honor, it's tab 33.
Oh, okay, I'm sorry, I did the wrong one. Thank you.
Can you repeat it again, sir? I'm sorry.
asking you, Chief, that you would accept my representation that there's 33 names on that sheet.
There could be. I don't see my name on there.
And on the next page, Chief,
Which page, I'm sorry?
the first page of the longer statement, the longer set of stats.
Okay.
Would you accept my representation, Chief, that on the second page, there's 32 names?
I'm sorry, Counsel. Which page are you looking at? I'm up to page 3 or 4 right now.
Your Honor,
Can you show me the page at least so I can? And that's page 1 and 2. So
yeah.
So which page are we on? 3.
So page 1, I'm asking you, would you accept my representation that there's 33 names on that sheet?
Yes.
Would you accept my representation that on the next page, which is labeled number 2, page 2, that there's 32 names?
There could be. Yes.
Okay. And on the third page, Chief, I would represent to you that there's 33 names. Will you accept that representation?
Objection. I don't know
Sure.
what that means.
Overruled. Let's move forward.
And Chief, if we go to the fourth page, you're 5 lines down from the top, correct?
Looks like I'm number 4.
And would you accept my representation again that there's 31 names on that sheet?
Sure. Yes.
Okay. The next page obviously has just the 2,
Correct?
and the next page has 7.
Yes.
Would you accept my arithmetic that that's 138 names?
I'll accept your math.
And Chief, the way this document's stylized, it lists the arrest in ascending order. So if we go back to page 1, there's 0 or very few arrests, and when we get to the bottom of the document, it's Lieutenant Dodge with the most arrests, correct?
Which page one are you on, sir?
The longer page 1, Chief. It'd be the 3rd page in this exhibit, in this count. If we look under arrest, everyone on that page has 0 arrests, correct?
Yes.
Okay. And if we go to the 7th page, where it ends with Lieutenant Dodge, he has the highest number of arrests, correct?
Would that be page 6 number 6. Up top?
Yep.
Arrests. Yes.
Okay. And then from Lieutenant Dodge, it's in descending order back through the rest of the document. Is that correct?
I'll agree to that.
And Pat Buchanan is on the second to the last page of this document, correct?
If you're referring to page 5, yes.
Okay. Will you agree with me, Chief, that there were no written documents from anyone in supervisory capacity to Pat Buchanan about his productivity?
If you don't have any, then I would agree to that. If you don't have any in front of you, I would agree to that.
Okay. Well, do you know any?
I do not.
Okay. And so during your tenure as chief, you never sent or caused to be sent any documentation to Mr. Buchanan relative to his production, correct?
That would be accurate.
And as chief, you have general superintendent of the department, correct?
I am the chief of the department.
If we could go to Chief tab 18 in the book in front of you. 18. Chief, looking at page 1 of tab 18, these are the internal affairs rules of the department?
Yes.
And they have been the rules that have been in existence during your tenure as chief?
Yes.
Could you... The second paragraph reads, to a large degree, the public image of this department is determined by how well it responds to allegations of misconduct against the department or its officers, correct?
Correct.
And it identifies the objectives of internal affairs investigations, correct?
That is correct.
Protect the public, protect the employee, protect the department, and remove unfit personnel?
Yes.
Okay. And those are all the reasons why the Internal Affairs Department exists.
It's the reason the policy exists, yes.
Okay. And then could you read aloud the next paragraph under that?
All alleged or suspected violations of laws, ordinances, bylaws, department rules and regulations, policies, procedures, and orders, verbal or written, must be investigated according to the procedures outlined for each.
So all alleged violations of law are to be investigated.
Sorry.
Correct?
Correct.
If I could turn your attention, Chief, to page 6 of this document. With respect to investigations of complaints, D1 says a superior officer shall be assigned by the chief of police as the officer in charge of internal affairs investigations.
That's what it says. I would strike the S. That's a typo.
And did the department ever, subparagraph B says the position responsible for internal affairs function has the authority to report directly to the chief, correct?
That's correct.
Did the department ever name someone specifically to be the internal affairs investigator?
No.
Okay. And then in paragraph or subparagraph 2 below, it identifies the categories of complaints, correct?
Correct.
And so complaints investigated by a supervisor are alleged rudeness, tardiness, and minor cases of insubordination, correct?
That's correct.
And are there other items that can be investigated by a supervisor?
Those are the categories within the policy to be investigated.
And then complaints subject to an internal affairs investigation include corruption, brutality, use of excessive force, violation of civil rights, and criminal misconduct, correct?
And any other matter as directed by the chief, yes.
But those are specified as things that are subject to investigation, correct?
Yes.
At the bottom of page 6, it talks about notification of the employee, correct?
That's correct.
Okay, so when there's an investigation proceeding, the employee is to be notified upon the start of the investigation, correct?
Unless those disclosures might compromise the investigation.
And the notification would give the employee a written statement of the allegation and the employee's rights and responsibilities relative to the investigation, correct?
Correct.
Okay. In 3, it says the time limits for the investigation should be completed within 30 days, correct?
Page 7, sir?
Yes.
Yes.
And only if there's extenuating circumstances would the investigation go beyond 30 days, correct?
Correct.
All right. And at the bottom of page 7, it's clear that off-duty conduct can also be the subject of an internal investigation, correct?
Correct.
And on page 8, this deals with internal investigations where criminal wrongdoing is the subject matter, correct?
Yes.
And And if the department has determined that the allegations could result in criminal prosecutions, the employee is entitled to their applicable constitutional statutory rights, correct?
That's correct.
Prior to being questioned regarding alleged personal involvement in criminal activity, it states the department employee shall be given their Miranda warnings, correct?
Yes.
And after the Miranda warnings have been given, any voluntary statement made thereafter may be admissible in a criminal proceeding, correct?
That's correct.
Right. So if you interview an officer and he or she gives voluntary statements after the Miranda warnings, those could be used.
Correct.
Okay. Which means that if the Miranda warnings weren't given, any statements taken would be excluded, correct?
Correct.
And then it says, and it may otherwise be used for departmental disciplinary purposes, correct?
Correct.
So after Miranda warnings, you can use the statements for departmental disciplinary purposes.
That's what it says.
If you don't have the Miranda warnings, if you haven't given the Miranda warning, you couldn't use the statements for departmental disciplinary purposes, correct?
Not necessarily.
And how would you be able to use them if it had to do with criminal conduct that you hadn't given them?
It wouldn't be done by the department, but statements later could come in.
Okay. But any statements given to you or an investigator that are not subject to Miranda warnings would not be able to be used in a departmental disciplinary process, correct?
Correct.
If we could turn to page 10, sir. Under heading, or number 9, investigative techniques. This allows the chief to order departmental employees for medical and laboratory examinations, correct?
Yes.
Okay. And the chief can order departmental employees to submit to alcohol testing, correct?
Yes.
And then if we go to page 12 under report of investigation. And it identifies that there's going to be a report of the investigation, correct?
Correct.
Okay. And then it indicates that the department is going to issue findings, correct? Sustained, not sustained, unfounded, or exonerated.
Correct.
And that's the rules by which the department is supposed to conduct internal affairs investigations.
Correct.
In the last page, under H, requires that any internal affairs investigations which may or does result in criminal charges being brought against an officer, that the district attorney or the attorney general's office shall be apprised, correct?
Correct.
If we can turn then three pages on from that, sir. And it's a page beginning authority. And maybe if you look at the next page. Do you recognize these as the rules and regulations of the Greenfield Police Department?
Which page are you on now, sir?
So I'm just trying to familiarize you with this part of the document, sir.
So the next page you have me looking at says receipt.
No.
Why don't you show the witness what you're pointing to, please?
It's a big book.
Yes. So authority, receipt, and then the rest of the document. Do you understand that the rest of this document is the rules and regulations of the Greenfield Police Department?
Yes.
Unfortunately, Chief, none of this is numbered, and so it's rules. So if I can address you to, it's the page after receipt, Chief. Do you see that?
Yes.
Okay. And you have point 40, professional conduct and responsibility?
4.0, yes.
Yeah. Could you read aloud the first paragraph, Chief?
Police department employees are the most visible and most readily accessible representatives of local government. They respond to calls for assistance of a diversified nature and are expected to resolve a wide variety of community problems as they occur. Police employees are professionals, and as such are expected to maintain exceptionally high standards in the performance of their duty while conducting themselves at all times, both on and off duty, in such a manner as to reflect favorably upon themselves and the department.
Chief, if I could turn your attention to the next page. Could you read aloud the first paragraph under privacy and off-duty conduct?
The department would generally limit its inquiry into employees' personal matters, off-duty conduct, and outside employment to situations impacting or reflecting upon the department or affecting the employee's ability or fitness for duty. An employee's right to privacy guarantees that disclosure of personal matters can be compelled only if the employer's interest in the disclosure outweighs the employee's privacy interest. When the department determines that inquiry into an employee's private life is legitimate, it will make an effort to keep the scope of the inquiry as narrow as reasonable under the circumstances.
Chief, if I could turn your attention to the conduct on becoming an officer, which is at 4.02. Could you read aloud, Chief, the two paragraphs at the bottom of that page?
Officers shall not commit any specific act or acts of immoral, improper, unlawful, disorderly, or intemperate conduct, whether on or off duty, which reflects, discredit, or reflect unfavorably upon the officer, upon other officers, or upon the police department. Officers shall conduct themselves at all times, both on and off duty, in such a manner to reflect most favorably on the department and its members. Conduct on becoming an officer shall include that which tends to indicate that the officer is unable or unfit to continue as a member of the department, or tends to impair the operation, morale, integrity, reputation, and effectiveness of the department or its members.
Could you read the paragraph on the next page?
Conduct on becoming an officer shall also include off-duty conduct where there is a nexus or connection between the act or acts committed by the officer and that individual's continued fitness or ability to effectively perform his or her required duties and responsibilities and or impact or adverse effects said contact may have on the operation, morale, integrity, reputation, or effectiveness of the department, and the ability of officers not involved in said activity to effectively perform their required duties and responsibilities.
Chief, if I could turn your attention to section 11.12. And this is entitled criminal conduct, correct?
Correct.
Okay. Could you read aloud what it says?
Officers shall not commit any motor vehicle or criminal act, felony or misdemeanor, or violate the regular or criminal laws or statutes of the United States or of any state or local jurisdiction by law or ordinance, whether on or off duty.
And then the note.
An officer may be guilty of violating this rule regardless of the outcome of any criminal case. Conviction of the violation of any law is prima facie evidence of violation of this rule. However, in the absence of a conviction, which requires proof beyond a reasonable doubt, an officer may still be disciplined under this rule for the conduct that was involved, since the preponderance of the evidence is the quantity of proof required in such cases.
And so what this means, Chief, is that an officer can be disciplined, correct, for conduct which occurs, which is criminal in nature, outside of a criminal proceeding, correct?
That's correct.
All right. So the department can take action against an officer even though the criminal matter hasn't resolved?
Correct.
Okay. The department can take action against an officer even if the criminal court has found that officer not guilty?
Correct.
Could we turn to paragraph or section 12.8, Chief? Could you read that aloud, sir?
12.8, required license. Officers must have and maintain a current Massachusetts driver's license.
And so if an officer doesn't have a current driver's license, that officer would be in violation of the rules, correct?
That's correct.
Okay. And so if the officer's license had been suspended due to operation under the influence of alcohol, that officer would be in violation of the rules.
That's correct.
Okay. And if an officer is requested to take a breathalyzer and declines, the penalty, as you understand it, would be a loss of license for how many days, sir?
Object.
Sidebar.
Right. Well, I have a sense where you're attempting to go with this. I'll hear from you on your objection.
Sure. He's attempting to say it's all about Clark, I think. I thought it was headed towards the flag. It's about Clark. Clark was never arrested. The suspension of the license for not taking a breathalyzer for context of an arrest. Once you're arrested, you can't do it not ahead of time. So Clark was never arrested. Charged.
Your Honor, I'm just asking him to state what he understands the rules are. That if you decline
but counsel is correct. It's subsequent to an arrest. Okay. So that the objection to stand is the form of the question. You can rephrase your question.
Thank you.
Objection sustained. You may rephrase your question.
Your Honor, it's 11 o'clock.
Okay, sure. We'll take a probably 15-minute break since we had a bit of a late start. With the ongoing instruction not to discuss the case with anyone, including amongst yourselves, nor to do any investigation or research or look at any media reports. I'll see you in 15 minutes. Thank you very much. Simply that. A moment, please. I do want to read into the record. I received an email from Judge Chernoff, only because I'm a stickler for ethics, and I don't want to engage in any ex-parte communication, which I'll simply read to you. And I'll tell you, I know Judge Chernoff. I do an annual program with him, which indeed I just did with him last month for MCLE. And this came in this morning at 9:35. Hi, Mark. I know that Lenny Keston is currently on trial with you. He and I co-chair the MCLE annual direct and cross-examination program. That it's an all-day event scheduled this year for Wednesday, April 27th. I've been concerned that his case with you may not wrap up by that date. The MCLE program will be remote, and we are trying our best to substitute other very experienced trial attorneys to pick up Lenny Kessen's segments. It will be very difficult to replace him as the cross-examiner of a particular expert liability witness in our morning tort demonstration. Is there any possibility that he might be available for a 30-minute direct and cross-examination demonstration? I fully appreciate the conflict, and if he cannot participate, then we will plan accordingly. Most sincerely, Paul. So I'm not going to write back to him, but I believe that we've already addressed this issue. I just wanted to go on the record and let you know that I did receive that, and you can explain to Judge Chernoff why I'm not getting back to him, because I'm in the middle of a trial, but I believe that this issue has been resolved, okay?
I have gotten back to him.
Okay, you're all set then. Thank you. I'll see you. Direct examination of Chief Hague.
Thank you, Your Honor. Chief, if I could turn you to Rule 14, which would be several pages down. And this is fitness for duty?
Yes.
Okay. Can you read aloud the first paragraph?
A police officer must be physically and psychologically fit to perform his or her public safety functions, especially since police officers are authorized to make arrests and carry firearms. If an officer is not fit, not only that officer, but also other officers, as well as the general public, may be jeopardized.
Just waiting, Chief, for it to load. To your left there. Thank you. Can you enhance that? Chief, the bottom paragraph, could you read the first sentence?
A police chief has the authority and indeed the duty to determine an officer's continuing fitness to perform police duties or return to full working status.
Could you read Rule 14.2?
Sick leave.
Yep.
Officers shall utilize sick leave for personal illness or physical incapacity only when thereby rendering unable to perform the duties of an officer's present position. Compensation for sick leave shall be subject to review by the chief of police, who may disallow such leave for improper or unauthorized use.
And under the contract, the officers have the right to take sick leave, correct, Chief?
Correct.
Okay. And how many days per year, Chief?
I honestly don't know.
Okay. And the days accumulate if they're not used?
Yes.
And when an officer were to retire, he or she would be entitled to some kind of payment towards unused sick days, correct?
Yes.
Okay. And if you believe there's been an abuse of sick leave, you have the right to inquire and examine as to whether an officer has properly or improperly used sick days, correct?
Correct.
Okay. And you never used that right to inquire with respect to Officer Buchanan, correct?
Not exactly.
Did you ever conduct any inquiry as to Officer Buchanan's use of sick days?
Not exactly.
So you didn't?
Not me personally, no.
Okay. And there's no documentation where somebody reporting to you conducted an inquiry, correct?
Correct.
All right. Could you turn to Rule 14.6? Could you read that aloud, Chief?
Possession or use of alcohol.
Could you read the rule aloud? I'm sorry.
Certainly. officers shall not possess and or use alcohol on duty other than in an authorized duty capacity. Officers shall not report for duty or be on duty while under the influence of intoxicating liquor or with an odor of alcoholic beverage on their breath.
And then 14.7, Chief. Could you leave the heading in the rule?
Off-duty use of alcohol. Officers off-duty shall not consume alcoholic beverages or medication to the extent that they are unfit to report for their next regularly scheduled tour of duty.
And if an officer were using alcohol on duty or they reported to work under the influence of alcohol, would they be unfit for duty?
Potentially.
Okay. And why wouldn't they be?
If they were under the influence?
Yes.
It's a different question than what you just asked. Can you just repeat the question?
If an officer were to report to duty under the influence of alcohol, would they be unfit?
Yes.
Do you agree that there was a civil service promotional exam given in the fall of 2014?
There could have been.
Okay. A civil service promotional exam for sergeant?
Yes.
And is your memory that 7 officers from your department took that exam?
I don't recall how many.
Is it your memory that Officer Buchanan topped the list?
Off the top of my head, I can't verify that.
Do you recall that only 2 officers topped that list?
Yes.
Okay. And who were the 2 officers who passed that test?
Officer Buchanan and Officer Haskins.
And the city had the right, or the town had the right, to petition civil service to promote from that short list, correct?
Yes.
Okay. And in the fall of 2014, there were 2 openings for permanent placement in the sergeants.
No.
No?
No, not 2.
Okay, how many were?
1.
Okay. How many promotions did you make in 2015, sir?
Could you clarify which list you're looking at?
How many promotions were made to sergeant in 2015?
I don't recall.
Is it your memory that more than 1 person was promoted in 2015?
If it was under the assessment, then yes, there were 2.
Okay. And those 2 spots had been open for over a year, correct?
That's possible.
Okay. And Jim Rode was serving as of the fall of 2014 as a provisional sergeant, correct?
Correct.
All right. And Officer Rode had been a provisional sergeant for how long?
I'm not sure.
And once there's a list that comes out, it's true, isn't it, that the list governs the promotion to provisional sergeant?
It depends.
Okay. And what does it depend on, sir?
If there are open positions that are unfilled, then you would utilize a list, regardless if it's certified, with names of folks that had passed.
And in the order of which they passed?
Not necessarily.
But the city had, or the town had the right to request and promote from that short list in 2014, correct?
Correct.
Okay. And you recall that both Haskins and Buchanan passed that civil service test?
That's what I recall.
Okay. And you don't recall that anyone else passed that civil service test?
I don't believe so.
Okay. And the promotions were made in September, October of 2015, correct?
If that is what I testified to in my deposition, then yes.
Okay. And that was pursuant to the assessment center.
That would be correct.
Okay. And so rather than use the civil service list for the promotions, the town went to an assessment center, correct?
That's correct.
Okay. And was it your recommendation to the mayor to request an assessment center?
Yes.
Okay. And so you were not satisfied with the promotional list that was given to you through civil service, correct?
Not correct.
Okay. Well, you asked the mayor to go to another method of promoting, correct?
That is correct.
Okay. So you had the option to go with civil service.
The mayor did, yes.
Well, you had the option to recommend using the civil service list.
Certainly.
Okay. And you didn't recommend that to the mayor, did you?
I didn't.
Okay. And instead of using that list for the promotions, you instead asked the mayor to allow you to use an assessment center, correct?
That'd be correct.
And the assessment center came back with the recommendation of Road and Haskins, correct?
I wouldn't call it recommendations.
Okay. Well, that's what the scores showed up, correct, sir?
The score is correct.
Okay. And those were in the order of who passed, Road and Haskins, correct?
I believe they were tied.
Okay. And then based on the Public Safety Commission, it became Road and then Haskins, correct?
That's possible.
And in fact, at the assessment center, Road and Haskins tied, and Mr. Buchanan was 1 point behind?
I don't recall the points, but
And you as chief were content with that list, correct?
yes.
Okay. And you recommended to the mayor that you go forward with the promotions of Road and Haskins, correct?
I recommended that to the commission. Correct.
Okay. And the commission recommended that to the mayor?
Correct.
Okay. And when you were speaking to the commission, you were speaking to the father of your first wife, correct? Among others.
Correct.
Did you ever tell Todd Dodge, after that October list came out, the results of that October test came out, that you felt Buchanan was lazy?
I don't recall that.
Did you tell Todd Dodge that Officer Buchanan, in your words, didn't fit the bill?
No.
Did you tell Todd Dodge to go check with civil service to see what he could do to get around the list that had Buchanan and Haskins as the two people up for promotion?
No.
Okay. But that's in fact what happened, isn't it?
Not accurate.
Well, there was a subsequent development, the assessment center, which resulted in getting around Pat Buchanan for one of those 2014 promotions, correct?
That's not my words.
But that's in fact what happened, isn't it?
That's not my words.
That's what happened. I'm not asking you what the words are. That's what happened, isn't it?
2 other people were promoted, yes.
Okay. And you didn't go with the list, the civil service list. You were able to, through another process, to come up with someone other than Buchanan for promotion, correct?
That's what the list produced, yes.
Object.
Please approach. Okay, what do you have? Let me just see what we're talking about here first.
Your Honor, these are two IAs having to do with Kelsenting, who's been the subject of some testimony.
You're going to seek to introduce them, is that correct?
Yeah.
Okay, all right. And you're going to inquire of this witness in what regard as to those two?
One, just the general nature, but also that because of these, or during these, on July 1, Kelsenting voluntarily retired from the department.
Okay, why do you need the entire IA just to get that in?
One, because he has no memory, I assume, without looking at the document, Your Honor.
Well, you could refresh his recollection, even if I'm not saying I'm going to allow it, but I'm not convinced yet that the entire IA needs to come in if you're just trying to get in that Mr. Ting retired. That's all you're seeking to get
That's
in.
all and I just want to approach him with
Well, I think it's just faster just to get it out of this witness. So why don't you just ask him and we'll take it from there, okay?
Just that.
All right?
Just that.
Yeah, just that. Why don't you pose a question first and then seek to refresh his recollection if it's necessary?
Chief, there's been discussion about Officer Ting earlier with respect to Officer Buchanan. You've heard that, correct?
Yes.
Okay. Do you recall the circumstances of Officer Ting's departure from the department?
I object.
You may ask a leading question only aligned with our communication at sidebar, okay?
Was Officer Ting the subject of...
No, sidebar. The question I was thinking was, did he retire?
Okay.
Okay, that's it. Okay.
Chief, do you have a memory as to whether Officer Ting retired?
Yes.
Okay. Do you have a memory as to when?
I don't recall.
Okay. Do you have a memory as to the circumstances under which he retired?
Your Honor?
Is that an objection?
Yes, sir.
Sustained.
Would you have a better memory if you looked at some documents?
Sidebar. All right. I take it there's going to be an objection to that.
I ask for you to instruct the jury that he's deliberately violating the orders. You have been clear on what he can do, and he keeps going
I take it there's an objection.
Yes, sir.
Okay. What is the possible relevance of the circumstances surrounding Officer Ting's retirement?
I'll move on, Your Honor. I
Strike
think it's
the
relevant.
question from the record.
Ladies and gentlemen, counsel's
Question is struck from the record. As I've told you before, I'll take once again that no question, no matter how phrased, ever constitutes evidence. Okay, let's move on.
Chief, if I could have you turn to tab 3, which is the Buchanan IA in Exhibit 1. And this is an IA that you ordered the inquiry, correct?
I don't recall if I ordered it, but yes, it's an IA.
Okay. And, well, did Lieutenant Burge have your authority to go conduct this investigation?
Yes.
Okay. And so he was acting pursuant to your authority?
Yes.
And on page 1 of the IA, it identifies the complainant as whom?
Daniel McCarthy.
Okay. And that's Sergeant McCarthy?
Correct.
Okay. And if we turn to the first narrative page, I believe it's 3 pages in, Chief. The last line in the second paragraph from Lieutenant Burge identifies that you assigned him to investigate the incident, correct?
That's correct.
And it started based upon the letter from Sergeant McCarthy to Lieutenant Burge, correct? Paragraph above?
If that's what it says in there, yes.
And then the second or the third paragraph identifies or sets forth the discussion between Sergeant McCarthy and Lieutenant Burge, correct?
Correct.
And McCarthy stated that this was the 4th or 5th time that he had heard Buchanan make these type of stipulations, correct?
Correct.
I object.
Overruled.
Is there anything on that page where McCarthy has any or sets forth any personal knowledge as to any occasion in which Buchanan made such a stipulation?
I don't quite understand your question.
I'm looking for you to identify any factual statement made by Sergeant McCarthy as to stipulations demanded by Buchanan.
Can you please pose a question?
That was my question, Your Honor.
It wasn't clear then.
Okay. I'm asking you, sir, to identify in that paragraph or anywhere else in the document any factual assertions by Sergeant McCarthy as to Buchanan making such a stipulation.
I'm not trying to be difficult. I guess I don't understand your question about
Please
facts.
rephrase your question.
If we look at the fourth line down, the paragraph said Sergeant McCarthy said this information was given to him by Detective Todd Clark. And that Clark was who he was referring to in his letter, correct?
Which paragraph are you in, sir?
I'm in the third paragraph, sir.
Third paragraph, okay. That's what it says in the paragraph.
So that's secondhand knowledge, correct?
That's what Sergeant McCarthy said to...
And then Sergeant McCarthy told Burge that he thought Officer Gilbert might have information about the incident and other stops. Correct?
Her name is referenced, yes.
Is there anything in this paragraph where Sergeant McCarthy is stating that he personally knows of such an incident?
No.
And then with respect to Detective Clark, he only testifies that, or he only writes as to one issue, correct?
I object.
Sustain us to the form of the question.
If we look at the next paragraph below, and this is Lieutenant Burge's discussion with Detective Clark, correct?
Correct.
Okay. Clark, other than the conversation with the woman, Ms. Patullo, the only other information he has is from an incident or a long time ago, correct?
That's what it says.
Okay. And then with respect to Officer Gilbert, which is at the bottom of this page, and this is Lieutenant Burge's discussion with Officer Gilbert, correct?
Correct.
And could you read the last 2 lines of that paragraph?
Officer Gilbert said that she felt it was strange, but Officer Buchanan was always trying to think outside of the box. I asked her if she had any knowledge of other incidents of this nature, and she said she had no personal knowledge of any other motor vehicle stops where Officer Buchanan had done anything like this.
During this investigation, Officer Buchanan was required to submit to a taped interview, correct, with Lieutenant Burge?
According to the report, yeah.
And that was part of the excerpt that was played the other day, correct?
Correct.
And the department sent personnel up to the Stop and Shop to ensure that the $10 gift card had not been used, correct?
If that's what's in the report.
Turning to Exhibit 4.
Tab 4.
Tab 4. This is the internal investigation notice of charges and allegations?
Yes.
Okay. And it was signed by you, sir?
Yes.
Okay. And it was sent to Officer Buchanan?
Yes.
Comporting with the rules telling him he was under investigation?
Correct.
All right. And then the tab 5. This is a notice of administrative leave, correct?
Correct.
And so you were placing Mr. Buchanan on paid administrative leave during the pendency of the investigation, correct?
Correct.
If we turn to tab 9. This is the finding that you have made, correct, with respect to the Buchanan IA?
Based on Lieutenant's investigation, yes.
Abusive position?
Yes.
Violation of the rules concerning gifts and gratuities, correct?
Correct.
Violation of the rules concerning conduct unbecoming an officer, correct?
Correct.
And you deem there's a violation of state ethics rules, too, correct?
Correct.
You state that each of the foregoing rules violation is serious and warrants significant discipline, correct?
Correct.
So in your view, serious discipline should have been imposed on any of these violations?
Please rephrase that as a question.
In your view, is it your view that serious discipline should have been imposed on any of these violations?
combined, yes.
Well, you said each of the foregoing rules violations is serious, correct?
That's correct.
Okay. So each of the rules violation is a serious violation.
Correct.
And they warrant each serious discipline, correct? Or significant discipline, correct?
Significant discipline, yes.
As a result of this investigation, you removed him as a field training coordinator, him being Mr. Buchanan, correct?
Correct.
Okay. And how long was he out as a field training coordinator?
I don't recall.
Okay. What did he have to do to be recertified as a field training coordinator?
I believe he was to work with the field training coordinator on that.
Okay, so it was up to the field training coordinator as to what the extent of the retraining would be. Is that your testimony?
Correct.
Okay. He was required to take a municipal employee conflict of interest training program,
Correct.
and that's done annually for the department?
Every 2 years by the city.
And how long is that video, sir?
I don't recall.
Half an hour?
I honestly don't recall.
He was suspended for 3 days without pay?
That's correct.
And he was demoted, correct?
Correct.
And he had been promoted within the last 2 to 3 weeks, correct?
Quite possible.
If we turn to tab 1, sir. Do you recognize that as the document promoting Mr. Buchanan to provisional sergeant?
No,
No.
that's not the promotional document now.
Okay, but that's an employment action form, correct?
That's correct.
Okay, and it's signed by you, sir?
Yes, it is.
And it's signed and dated 1/13/2015?
Yes.
Okay, so would that be contemporaneous with the promotion, sir?
Yes.
Okay, and if you look at on the effective date of action, it's in the middle box there.
Yes.
It says 1/13/2015?
Yes.
Okay, so pursuant to this, the promotion took effect 1/13/2015, correct?
Yes.
In returning to tab 9, which is dated January 30th, 2015, the demotion would have taken effect on or about January 30th, correct?
Correct.
In your tenure as police chief, is there any other person who you promoted and demoted for cause within a 3-week period of time?
Not to my recollection.
Mr. Buchanan's the only one.
That's what I recall.
Read aloud, go to the next page, sir. Read aloud the 3rd paragraph.
Which tab are we in now?
I'm sorry, sir, tab 9. Could you read that aloud?
The whole page?
No, the 3rd paragraph. I'm sorry.
The city of Greenfield demands and deserves the highest level of credibility and trust from its police department. Furthermore, we owe our officers and those future officers to be trained in a manner which will be fair and impartial based on the authority we have been granted.
Okay. And read aloud the first sentence in the next paragraph.
You place the Greenfield Police Department in a negative light by overstepping your authority to create punishments which are not part of your discretionary powers.
And so one of the complaints was that he created punishments that he does not have the authority to create, correct?
Correct.
And later on, in the middle of that paragraph, you write, this is not part of a police officer's training, nor is it part of your discretionary powers under the law, correct?
Correct.
Right. And while I respect the ability for you to use your lawful discretion, creating a personal and arbitrary alternative punitive option is not one of them, correct?
Correct.
Both the supervisors and the rank and file are subject to collective bargaining, correct?
Correct.
And under the collective bargaining agreement, there's a tight time window to file an appeal, correct?
I don't recall exactly.
If I suggested to you it's 48 hours, does that sound correct?
If that's what's in their agreement.
Okay. And the, well, let's turn to tab 11. This contains 2 letters, correct?
Correct.
One to you and one to the mayor?
Correct.
All right. And it's from Sergeant Dodd on behalf of Provisional Sergeant Buchanan, correct?
Correct.
All right. And Dodge informs you that the Supervisors Union intends to file an appeal of your discipline on Buchanan, correct?
Correct.
All right. And if we look at the last line on that page, this letter should be considered notification of the appeal, which should satisfy the 48-hour reporting notification deadline.
Correct.
All right. And so does that refresh your memory that there was a 48-hour window within which to file an appeal?
That's what it says here.
And there was an appeal to the mayor?
I'm sorry, sir?
There was an appeal to there was an appeal hearing held in front of the mayor, correct?
That's my understanding.
Okay. Were you there?
Briefly.
Okay. Did you testify?
I don't recall.
Do you recall Mr. Buchanan testifying?
I don't recall.
Do you recall Sergeant Dodge being there?
I assume he was there.
And the mayor issued an order affirming your discipline?
I believe so.
And that then was subject to a further appeal, correct, sir?
That's correct.
And were you at the appeal hearing in front of the arbitrator?
I was.
Okay. Was Mr. Buchanan there?
To the best of my recollection.
Okay. Was testimony obtained at that hearing, sir?
I believe so.
Okay. Did you testify?
Yes.
Did Mr. Buchanan testify?
I don't know.
Okay. Did Sergeant Dodge testify?
I don't know.
Okay. So you were only there for a portion of the time?
I believe so.
Okay. Chief, I'm putting in front of you what's previously marked as Exhibit 2.
Yes.
Do you recognize that?
I do.
Okay. And that's IA case 16-3-IA?
Yes.
Could I see that?
It's the exhibit in evidence.
I don't understand.
Because it's not in the binder.
Well,
I believe it's the Clark IA.
Yes.
oh, okay. I just want to see what it is. And then they marked it, okay. This is what-
Original. But it's Chief.
Yeah, they marked it. I clicked it.
You recognize this document, Chief?
Yes.
Okay. And Sergeant Clark, well, this deals with Todd Clark, correct?
Yes.
Okay. And Todd Clark was promoted in 2020, correct? 2020, 2021.
2021, I believe.
And Todd Clark was ranked by you as the #1 candidate, correct, sir?
Sounds accurate.
If we could turn in this document, sir, to I believe it would be the 5th page. It's a note or a memo to you from Detective Brooke dated 1/16/2016. You see that?
Yes.
Okay. And who is Detective Brooke?
At the time, he was our school resource officer.
Is he still with the department?
He is retired.
Okay. Could you read aloud the first 5 sentences in that document?
Chief, on Friday, January 16th, 2006, at approximately 0700 hours, Detective Clark and I were entering the station together. Once in the station and in the Detective Bureau hallway, we were having a conversation. I was talking with him outside of his office, and I sensed that he was not his normal self. His speech was slurred, and he seemed to be unsteady on his feet.
The next sentence?
He took his jacket off, and when he attempted to hang it up, he appeared that he stumbled and almost fell, but was able to catch himself.
This, when he states in the memo, Friday, December 16, 2006, you take that to mean it was Friday 16, January 16, 2016, correct?
I would assume that's a typo.
Okay. And so he's reporting to you the fact that Detective Clark appeared to be under the influence of alcohol, correct?
That's what it says in the letter?
Okay. And it's at 700 hours at 7 a.m., correct?
Correct.
And so he's just reporting, both of them are just reporting into work.
I don't know what their schedules were that day.
Detective Brooke was a school resource officer,
Correct.
so he would have been going into the schools at about between 7 and 8.
At some point, he would go to the school.
Okay. And Detective Clark rated the day shift, correct?
I don't know what his actual schedule was.
Did you see later on in this note that Detective Brooke complained that Detective Clark made comments about Detective Brooke's child's sexual orientation?
I don't see a reference to sexual orientation.
What are you referring to?
If you eight lines down at the far end, I'll read it to you. He stated to one of my sons that it is okay if he is gay and that I will accept him. And if not, then he will beat me up. Correct?
7, 8, yes.
So Detective Clark was making these comments to this young man.
That's what Detective Brooke wrote.
Okay. And then at the bottom of the sheet, Detective Brooke indicates he advised Sergeant Dodd, correct?
That's what it says.
Okay. I advised him of Detective Clark's behavior and my belief that he was intoxicated, correct?
That's what it says.
Okay. And then the last line, at approximately 12:15 hours this same day, I was requested by Lieutenant Burge to come see you, correct?
That's what it says.
Okay. So this to from memo is after your meeting with Detective Brooks, or Brooke, correct?
I don't know the order in which the memo was written.
Okay. But it's to you after he was advised to go see you, correct?
It's to me.
And what action, sir, did you take in January 2016 with respect to reports that one of your detectives was under the influence of alcohol at 7 a.m.?
Can you be more specific?
I'm asking, what actions did you take in January 2016 with respect to reports that one of your detectives was under the influence of alcohol in the station at 7 a.m.?
January 2016?
Yeah.
I think his dates are wrong.
Well, twice in the report, he identifies it as January 16, 2006 or 2016, correct?
Correct.
So the question is, what did you do in response to this in January 2016?
In January of 2016, is that what you're asking me?
Yes.
Nothing.
And if we turn back to the front page of Exhibit 2, the date that IA report was opened is when?
December 16, 2016.
And this document would have been shared with you, correct? On or about the date it was produced.
Please clarify what date you're referring to as the date that it was produced.
The document that's dated 1/16/2016 and addressed to you, that would have been shared with you on or about the date it was produced, correct?
You're all right. This is object. It's confusing.
The objection is to answer the point of the question. Can I see counsel at sidebar? Attorney McDonough. So now your client, Lieutenant Dodge, has spent a good portion of this trial on his phone.
I'll talk to him.
Okay. I know he's not recording. I'm not going to stop him. That's the message that he wishes to send to these jurors who can plainly see that he is more attentive to whatever is going on his phone, and that's his prerogative. But it's gotten out of hand. Okay.
I'll speak to him.
Thank you.
Thank you.
Please rephrase your question.
Thank you, Your Honor. Your best memory, Chief, as you sit here today, is that you took no action in response to this document that's dated 1/16/2016, correct?
Not to my recollection.
And then if we turn to Exhibit 2, this IA was opened when?
December 16th, 2016.
Do you recall testifying at deposition, sir?
What page? Which one, what page?
That there were rumors.
What page?
Would be deposition 2. And it's page 32.
32, thank you.
Let me withdraw the question. Was Clark's involvement with alcohol something that had been long-standing within the department?
I don't know.
Were you aware of any statements within the department?
I object.
Sustained. Statements as to what, please?
With regard to his alcohol involvement?
Statements?
Statements made by other officers.
I wouldn't classify them as statements.
Would you classify them as rumors?
I would.
Okay. And there were rumors within the department that you were aware of regarding his involvement with alcohol, correct?
I'm sorry, repeat that?
There were rumors that you were aware of regarding Detective Clark's involvement with alcohol, correct?
I heard rumors, yes.
And the rumors predate your arrival at the department, correct?
I think that's fair.
Turning to back to Exhibit 2, if we go to the first page on the narrative. It details, the first paragraph details a meeting you had on September 19, 2016?
Yes.
Okay. And this was a meeting with you, Sergeant McCarthy, and Detective Clark, correct?
Correct.
And what was addressed at that meeting was the fact that he had come to a fair detail, that Todd may have come to the fair detail while intoxicated, correct?
May have come, yes.
And this was a report, or this matter was brought to your attention by Lieutenant Burge, correct?
Yes.
Okay. And did Lieutenant Burge ever commit to writing, commit to paper, his observation about a fair detail at which Officer Clark may have been under the influence?
I don't recall.
Did you direct him when he spoke to you prior to the September 19, 2016 meeting to detail it in a writing to you?
I don't recall.
If he's doing a fair detail, he's on duty, correct?
Correct.
And so the rules apply to Detective Clark when he shows up for that fair detail.
Correct.
Okay. And if he's at a fair detail and he's under the influence of alcohol and appears to be intoxicated, would that present a good public image for your department?
No.
Would that be conduct unbecoming, sir?
Would that? Yes.
Yes. And it's a violation of other rules that we looked at earlier, correct?
Correct.
Okay. Was anything done with respect to the fair detail at which he was under the influence to start an IA or to impose discipline with respect to that incident?
Not that I recall.
The next paragraph. Other concerns that have been brought to light included incident involving a late night car crash in which alcohol may have been an issue, correct?
Correct.
Okay. And so this is a late night car crash involving Detective Clark, correct?
Correct.
Okay. And when in time predating September 19, 2016 was that accident?
I don't know.
Was any investigation done by the department at your direction to investigate whether alcohol had a role with respect to that accident?
No.
The sentence continues, along with a concern of his coming to work while on call intoxicated, correct?
That's correct.
Okay. So this is yet another incident, correct, sir?
Rumored incident, yes.
Okay. Well, he came into the station while on call.
May have, yes.
Okay. Any date, sir, for that incident?
No, not that I'm aware of.
Any investigation by any with respect to that incident where there's a concern he showed up on call under the influence?
Not to my knowledge.
Okay. Again, that would be a violation of the rules.
Yes.
Okay. And if he's driving to the department from his home, or he's driving to a fair from his home, wouldn't he be in violation or potentially in violation of the rules prohibiting driving under the influence?
Potentially.
Okay. And was any investigation done with respect to whether Officer Clark was driving on either of those incidents?
Not to my knowledge.
Okay. And is it legal for a person to have in his possession or in his vehicle a firearm when they're under the influence?
You can't have a firearm when you're under the influence. Correct.
And that's a separate citable offense, correct, sir?
Probably.
Okay. And it's a misdemeanor?
I don't recall.
If I were to show you a section of the general laws, would that refresh your memory, sir?
Sidebar.
You know, to be fair, there's a distinction to be drawn between being under the influence and drinking. One does not necessarily equate to another. And while there's been no objection to this line of questioning, what the law addresses is individuals who are under the influence, okay? Not simply drinking. So I don't know where this is going, but it's misleading unless there is some foundational evidence that Clark was under the influence, okay, as opposed to simply drinking alcohol. So I take it you have that provision of Chapter 90 that relates to the misdemeanor offense. So where's this going then?
Your Honor, I'm just going through the evidence here as to the comparator.
Oh, I get that.
Yeah.
Yeah. That's not what I'm trying. I'm taking a closer look at this particular line of questioning, which is an important line of questioning in terms of comparative evidence. I get that, okay? And it's coming in, or at least has been coming in thus far. What I'm focused on, though, is the line of questions that relate to statutory authority as to an individual is under the influence, okay? There's been no evidence that Clark was ever under the influence, okay? So it is a bit misleading to pose questions as to what is the law when someone is under the influence when there's no foundation laid that Clark was under the influence at the time.
And obviously, Your Honor, you can only determine somebody's under the influence if you do the investigation following, probable cause.
That's fine, but that's not the point, okay? Having said that, there's no objection to this line of questioning, but it's of concern to me, okay?
As I understand the rules, when you're refreshing witnesses' recollection, you're not supposed to say what you're showing me.
Well, that's a separate issue in terms of how we just got to this. So I'm going to have you go back and get some thought as to what I just said, and let's proceed.
Okay.
Ladies and gentlemen, feel free to stand up and stretch. We'll go just to 1 o'clock or so, and then we'll recess for the day. Okay? Please pose another question.
Detective Brooke had training with respect to observations and stops with respect to people who were under the influence, correct?
Correct.
Okay. And Lieutenant Burge would have had similar training?
Correct.
Okay. And with respect to paragraph 2 of the document we're looking at, there's comments that were brought to your attention, correct? Concerns brought to your attention, correct?
Correct.
Which paragraph?
Paragraph 2 of the narrative. Yes. Yeah. And those would have been comments or concerns that would have been brought to your attention by a member of the police department, correct?
Which paragraph are you referring to now?
The second paragraph, sir. Other concerns have been brought to light?
I would assume so.
Yeah. And you have no reason to believe they were brought to your attention by someone outside of the police department. Is that a fair statement?
I would say it's a fair statement, sure.
And so anyone within the police department who brought those concerns to your attention would have had some training and experience with respect to motor vehicle stops and when someone is or is not, when there is or isn't probable cause to believe that person's under the influence.
Did you say all?
The persons who brought that to your attention had training, correct?
Possibly.
Okay. In motor vehicle stops, correct?
Possibly.
Are there people in the department who don't have the training?
Yes.
Okay. Sworn officers?
Not sworn officers, no.
So with respect to sworn officers, are there any sworn officers who don't have the training as to how to conduct a motor vehicle stop?
I don't believe so.
And based upon their training, they have the ability to identify when there's probable cause to identify someone as under the influence, correct?
I'm sorry, can you start
Based
the name
upon their training,
Correct.
they have the experience and the knowledge to identify, at least for the purposes of probable cause, when someone is or isn't under the influence of alcohol.
Fair statement.
And then, Chief, the last line in there is about, in that paragraph, is Detective Clark's personal vehicle had been followed, correct?
That's what it says.
Are there any documents or any papers within the department that relate to that incident where his personal vehicle was followed?
Not that I recall.
And so the plan put in place on September 19 was what, sir?
Do you want me to read this?
Well, you can identify it, you can read it, whatever is easier, sir.
A plan has been put in place which involves voluntary PBTs when I or Sergeant McCarthy asks to ensure he is being sober. Should this fail, he was advised, I did not have a lot of faith in this method, that he would have to seek treatment or would not be allowed to come to work.
And in the paragraph above, you quote Todd Clark, correct? In the third paragraph?
There are no quotes, but I obviously put what we talked about.
Yeah. And that you're stating he did admit there may have been times he has come in while on call and has been drinking prior, correct?
Correct.
Okay. What further exploration did you do as to the date, time of those occasions when he came in on call?
I don't recall if we went into dates and times.
Okay. And what further investigation did you do or information did you elicit from Officer Clark as to how much drinking he had been doing prior to coming into work?
I don't recall.
And you agree that if somebody comes in with an odor of alcohol on them, it's a violation of the rules we looked at earlier, correct?
Correct.
It's not only being under the influence, it's the odor of alcohol, correct?
Correct.
Now, later in this in the sixth paragraph, it details conversations you had with Sergeant Dodge, correct?
Correct.
And Sergeant Dodge's belief that Officer Clark was under the influence.
No.
Okay. Okay. In any event, you did go to the courthouse that day, correct?
Yes.
And you became the investigating officer, correct?
Correct.
Okay. Nobody else did the investigation?
No.
Okay. And under the rules say that you assign it out to someone, correct?
I signed it to myself.
Okay. And you were also going to render a judgment on the case, correct? In a preliminary manner.
Possibly.
Okay. Who else would have rendered any kind of decision, if not you?
In this case, no one.
Okay. So you were the investigator as well as the person who was going to impose discipline?
Potentially.
Okay. Well, when you left the station to go to the courthouse, was there anyone else who was going to impose discipline?
No.
you and Detective or Sergeant McCarthy brought Detective Clark into the men's room, correct, at the courthouse?
Correct.
Okay. And this was a temporary courthouse that was located on the other side of I-91, correct?
Correct.
All right, not the one in downtown, but several miles away.
Correct.
And the purpose for bringing him into the men's room was to have him take a portable breath test, correct?
Potentially.
Okay. Well, did you have a portable breath test with you?
I did.
Okay. And so you brought it there to have him take a portable breath test?
Potentially.
Okay. In the second paragraph to the bottom, you record what you observed, correct? On this first page of the narrative?
Yes.
And you record that his speech was slurred and thick-tongued, correct?
Correct.
And an odor of alcoholic beverage could be noticed from his person, correct?
Correct.
Detective Clark was unsteady and repeatedly leaned against the wall?
Correct.
The next paragraph reads, I advised Detective Clark he had driven a department vehicle to the court, correct?
Correct.
Okay. And that's an accurate statement?
To the best of my knowledge.
So he'd taken one of the cruisers from the station and driven it to the court?
Yes.
Okay. And you state that you believed he may be under the influence, correct?
Yes.
And you asked him to take the portable breath test?
I did.
And what did he do, sir?
He initially said he would take it.
Okay. And then what did he do?
He said he would not pass it.
And then if you read the last sentence at the bottom of that page, aloud.
Which sentence, sir?
Beginning with I asked him?
I asked him if it would show he was under the influence and that he would fail the BT, and Detective Clark said yes.
At any time, did you give him Miranda warnings?
No.
Okay. At any time, did you require him to go back to the station to take a certified breath test?
No.
But you had an admission from him that he was under the influence and he would fail the breath test, correct?
Yes.
And at that time, you took keys for two sets of vehicles, correct?
Correct.
From Detective Clark?
Correct.
Both his cruiser and his personal vehicle?
If I recall.
And rather than take any formal action, you drove him home that day, correct?
I did.
Detective Clark told you he doesn't drink often, but when he does, he doesn't stop until he's completely drunk?
That's what the statement says.
He advised you that on 2 occasions he had recently driven home after drinking and that he shouldn't have?
If that's what it says.
That he can go days without drinking, but if he starts, he can't stop until he's completely drunk, correct?
If that's what it says.
And Detective Clark then again admitted he was currently under the influence, correct?
If that's what my report says, yes.
Okay. In addition to driving from the station to the courthouse, he'd also driven that morning from his home to the station, correct?
I assume so.
And there were no investigation with respect to whether those actions violated Massachusetts law?
No.
Is there an exemption? Well, police officers are subject to the same rules, correct?
Correct.
Okay. And so if they're under the influence, they are subject to the same rules that make it illegal conduct, correct?
Correct.
Would you say that you had probable cause to believe that he had driven while under the influence on at least 2 occasions that day?
Potentially.
Okay. And no action was taken by you, correct? Other than to drive him home?
At that time?
Yeah.
No.
Was any disciplinary action ever taken by you with respect to any of these incidents?
No.
Okay. If we can turn to the last page of this document.
Can you just give me an actual page?
Just
so I know what it is.
I'm sorry, Chief. It's your letter dated January 12th,
Okay.
2017?
Yep.
And this is the letter that closes out this incident, correct?
That's correct.
And so there was no internal affairs complaint issued against him, correct?
The IA is right here.
Okay.
63-IA, the one we're talking about.
If you recall, there was a notice of charges and a notice of administrative leave that were sent by you to Officer Buchanan, correct?
Correct.
Okay. Was anything similar to that sent to Detective Clark?
No.
And he wasn't formally placed out on administrative leave, correct?
Correct.
Okay. You asked and he went to a outpatient program?
I'm not sure what the actual schedule was.
Okay. But a program up at the Brownsboro Retreat, correct?
I believe that's where it was.
Paragraph 3 of your letter. Well, let's go to paragraph 2. You state you had many in-depth conversations with him about the incident?
Yes.
Okay. Are there any documents, sir, that memorialize those conversations?
Not that I'm aware of.
And you, as you sit here today, don't recall when and where those conversations were?
Not exact locations, no.
And in paragraph 3, you state that the department was able to take this action, which is not to take any action against Officer Clark, for the fortune that your dangerous behavior did not cause undue public embarrassment to the department, correct?
Can you say that again?
You state in paragraph 3 that you were able to resolve this with no discipline because it's your words, for the fortune that your dangerous behavior did not cause undue public embarrassment to the department. End quote, correct?
I object. That's what it says.
I'll ask you simply to read directly from the report.
Your letter states, you acknowledge by admitting to a problem with alcoholism and by taking the route offered by your contract to seek counseling were allowed by this department only for the fortune that your dangerous behavior did not cause undue public embarrassment to the department, correct?
That's what you read, yep.
And public embarrassment to the department would have been the arrest of an officer for on-the-job, for operating a cruiser while under the influence, correct?
No,
It wouldn't have embarrassed the department.
maybe.
Okay. You had the option to arrest him on that day, or to take him up to the department and have him take a breathalyzer.
Potentially.
Okay. And if you had done so, there would have been records, correct?
Certainly.
Okay. And if you had arrested him, he would have been brought to the district court, correct?
At some point.
Okay. And that would have been the subject of
Overruled.
press scrutiny, correct?
Potentially.
And that would have led to the public embarrassment of the department, correct?
Potentially.
Okay. Is it your statement that the arrest of an officer for operating a cruiser under the influence of alcohol would not publicly embarrass the department?
I don't know.
Okay. You haven't formed a belief as to that?
No.
Okay. And the rest of that sentence says, or other circumstances which could have been deemed egregious, correct?
That's what it says.
And when you wrote that, what other circumstances were you contemplating that could have been deemed egregious?
Sitting here now, I can't recall.
But it was your discretion to take him in and arrest him, correct?
Yes, it was.
Okay. And it was your decision not to take him in.
Yes, it was.
And it was your decision not to get a blood alcohol reading as to what his blood alcohol level was, correct?
Yes, it was.
Okay. And you had the right to, as an officer, to bring him in and require him to take a reading, correct?
If I arrested him.
Yeah. Is there any doubt from the records that you've seen that he was in fact under the influence at that time and date?
Can you rephrase that or
Is there any
clarify
doubt
that?
he was under the influence on that time and date?
No.
And that he had been operating both his own vehicle and the department's vehicle?
Yes.
Correct?
You're correct.
Yeah. And you chose not to require him to come to the station and take a breath test.
Counsel, let's move forward, okay? Asked and answered, thank you.
If you had required him to take such a test, he would have had two options, correct?
In which capacity?
To either agree to take the breath test or not to agree to take the breath test.
If he was arrested?
Yeah.
Yes.
Okay. And both of those have consequences, correct?
Yes.
Okay. And if he didn't take the breath test, there's a consequence, correct?
Correct.
Okay. And what is that consequence?
Your license is suspended.
For 180 days?
It's been a long time since I've been on the street, but probably.
And if he took the breath test, there'd be a record, correct?
Correct.
All right. Showing what the blood alcohol level was, correct?
I assume so.
Okay. And you also, as the chief under the rules, had the right to require him to go to the hospital and get a medical exam as to what his blood alcohol level was, correct?
Correct.
And again, in connection with your work that day, at no time did you read Detective Clark his Miranda warnings.
I already said no.
you came back to the station, did you move Detective Clark's car?
I don't recall.
Did you come out of Detective Clark's car with any kind of bottle?
Yes, I believe I did.
Okay. And what kind of bottle did you bring, sir?
I don't recall exactly. I believe it was a vodka bottle.
Okay. And where was that in Detective Clark's car?
I don't recall off the top of my head.
Was it on the center console?
I don't recall.
Okay. And was his car kind of parked crosswise in the lot, and that's why you had to move it?
I believe I recall having to move it.
Okay. And you didn't know anywhere in your report that you took a bottle of vodka out of his car, did you?
I don't know.
Well, look, do you see it?
I'll go through it. If you're telling me it's not there, I'll believe you.
Let's move forward.
Under the rules, if there's a violation, you're supposed to refer him to the DA's office or to the Attorney General's office, correct, sir?
Potentially.
All right. Well, if there's a probable violation of law, you're supposed to refer it to the DA's office, correct?
Correct.
Okay. You didn't refer this matter to anyone, correct?
No.
Can we turn to tab 26?
Would you like this back, counsel?
We can put it on the table at the end. Thank you.
10 more minutes, counsel.
Which tab, sir?
Tab 26?
26.
Do you have that there in front of you, sir?
I do.
Okay. And this is an IA that has to do with Sergeant Dan McCarthy, correct?
Yes.
Okay. And this is an IA involving his conduct with respect to a Max Hamill.
I believe so.
And this involves this Max Hamill and Sergeant McCarthy's daughter, Cassie, correct?
I believe that's her name.
Okay. And she's an adult, correct?
According to this, yes.
Okay. If I turn your attention, sir, to the narrative report, which I think is the third page in, and it says narrative, page 1.
Yes.
The second paragraph, sir.
Yes.
And this is a statement from Sergeant McCarthy to Deputy Chief Williams. Correct? If we look at the top under entry ID and modified ID, that's Deputy Chief Williams's.
That is.
Correct.
Correct.
Thank you. And so in the second paragraph, this is Sergeant McCarthy explaining to Deputy Chief the background.
Yes.
Okay. And there's an allegation that the young man attempted to force himself on the young lady.
That's what it says.
Okay. is that any kind of sexual assault?
Potentially.
Okay. Did the department ever obtain any statements from Miss McCarthy substantiating or claiming that she was sexually assaulted?
I don't recall.
As of the time of this incident of September 19, 2016, had there been any complaints with the department that Miss McCarthy was the victim of a sexual assault?
I don't know.
Okay. Do you have any reason to believe it had such knowledge?
I don't know.
Turning to page 2 of this. The large paragraph just below the mid-page. These statements in there are pursuant to a to-from memo from Sergeant McCarthy, correct?
What are we looking at?
Page 2, the big paragraph just below the middle of the page. Correct, it's from a to-from memo?
That's what it says.
Okay. And Sergeant McCarthy relates to Detective Williams' statements he heard through Detective Clark, correct?
Deputy Chief Williams. That's who he was speaking to.
Yes. But Sergeant McCarthy relates to Deputy Chief Williams' statements he had heard from Detective Clark, correct?
If that's what it says, yes.
Okay. And it had to do with a potential sexual assault as well as photos of young Miss McCarthy, correct?
Correct.
Okay. And Cassie reported, I'm reading, also reportedly told Detective Clark that Max may have somehow come into possession of personal photos of her and that Max was now threatening to post them on Facebook, correct?
That's what it says.
Okay. Did the department ever obtain any statements from or any writing from young Miss McCarthy to corroborate this statement?
I don't know.
Is it your memory that in connection with this investigation, Miss McCarthy refused to meet with your investigator?
I don't recall.
If I can turn your attention to page 8 of this document.
I'm assuming the narrative?
Yes, the narrative. Thank you, Chief.
Yes, sir.
Could you read aloud the paragraph that says on Monday, September 19th?
On Monday, September 19th at 09:30, Chief Hagan and I spoke briefly with Sergeant McCarthy about the importance of the interview with Cassie. Sergeant McCarthy said he understood the importance of speaking with her and also why he should not be in the interview. He said he would speak with his wife, Monica, and see if she's willing to assist Cassie with this.
Turn your attention to the bottom line on page 9 and over on to 10. Could you read those aloud?
On Monday, September 26, 2016, I sent a text message to Cassie McCarthy asking her again for the opportunity to speak with her, but also reminded her that I could not do it with her father present.
Could you continue?
I did tell her it was possible to have someone else there if she was still uncomfortable with speaking with me alone. Cassie replied, "Sorry, I want him there." I advised Chief Haig of Cassie's refusal to meet with me again. Chief Haig still agreed that the interview could not happen with Sergeant McCarthy in the room due to the nature of the investigation.
So does that refresh your memory as to whether you were able to obtain any documents or any interview of young Miss McCarthy?
And based on that paragraph, I would say no.
Okay, know that you didn't obtain an interview and you didn't obtain any documents.
As of that paragraph, no.
All right, very well. Ladies and gentlemen, it's 1 o'clock. We're going to recess until tomorrow at 9 o'clock. I don't anticipate that we'll have a late start as we did today with the ongoing instruction, not to discuss the case with anyone, including amongst yourselves, nor to do any investigation or research or look at any media reports. See you tomorrow morning. Have a great afternoon. Thank you.